Yeah. Great, thanks, Becca. My name is Kim Branham. I am the Victim Rights Specialist with the Division of Criminal Justice. I handle all of the Victim Rights Act complaints across the state. Typically, we do this training in person. I'm glad that we're here to be able to do it virtually for you. But it's always nice to, I always like to get a hands raised as to who's done the training before. But I think at this platform, it's hard for me to be able to see that. So maybe Becca, can you just let me know maybe percentage wise of how many have already attended this training and it's just kind of a review, or do we know how many this is brand new to them?
I believe over 50% have attended this training.
Okay, good, thank you. Yeah, I just like to know kind of who the audience is. I appreciate you guys that have already seen it, and it'll be a review for you. It's always good. We haven't had a whole lot of changes to the VRA over the last year, but I think it's always good to have that refresher. So feel free to ask questions along the way if you guys would like. I'm open to any discussion. I would like it to make it about you guys if we can, or you can put it in the chat, and hopefully Becca can maybe keep an eye on that chat and let me know if questions do come up. So we'll talk a little bit about the history of the Victim Rights Amendment, where it came from. It started back in 1982 when President Reagan had an assassination attempt made upon his life. He was going through the criminal justice system as a victim, which was new to him. And he realized that he wasn't receiving information. He wasn't getting the resources and the services that he felt that he deserved as a victim. Being the president, he felt that, wow, if I'm not receiving this information, what are victims of crime not receiving? Because it's got to be a lot less than what I'm getting right now. So he created a task force and asked for the task force to go out and talk to victims of crime and interview them to find out what they liked about our criminal justice system and what they would like to see change. When they came back and reported to the president, they had reported that we were at a national disgrace on how our victims were being treated. And had they had the opportunity to report the crime, they never would have done it in the first place because of the way that they were treated by the perpetrator, or because of the way they were being treated by the system and not necessarily the perpetrator. So we figured in our nation that we needed to make some changes for our victims. So Colorado's, we passed our Victim Rights Amendment in November 3rd of 1992, and it went into effect on January 14th of 1993. We passed with over 80% of the votes, which is pretty awesome. This is a map of our nation. It shows the states that have an enforcement and compliance process to them. So all of those light colored purples are the states that do have a complaint process. So if a victim feels that their rights are violated, in the purple states, they can file a complaint, and they would do so from Colorado out of my office. The darker color purple states do not have an enforcement or compliance process. So it doesn't mean they don't have victim services. It doesn't mean they don't have, available resources for victims. They just don't have that enforcement piece. So if a victim felt that their rights were violated, they wouldn't have a process to go through to help validate them and to make change in their state. In our Colorado Constitution, we have three things listed that are underlined here that are the victim's rights to be informed, the right to be heard, and the right to be present. These are the three things I believe that task force came back and reported to the president that were most important to victims that they were lacking. So they weren't being provided that information of what was going on with their case. They weren't allowed to be in the courtrooms, and they weren't allowed to be heard during that process. So these are the three things that we have added to our Colorado Constitution because we felt that these are the most important. And we will talk about those as we go through the training today. In our legislative declaration, I always think that this is a goal. This is a goal for us as a state. I don't think we're necessarily there yet. Saying that our victims and witnesses to crimes are going to be protected by law enforcement, prosecutors, judges in a manner no less vigorous than the protection afforded to criminal defendants. Basically stating that we are going to treat our victims better than we treat our defendants. So I think it's a goal. I think it's something that we constantly are working towards. I always use the whole experience with COVID and how that really impacted victim rights. We saw a big uptick in our victims filing complaints with our office because there was this big push to release inmates out of custody. Victims were not being notified when they were being released from custody. There was a lot of that notification that was missed because we had so many people that were trying to get inmates out of custody. The other part of it too is that if there was hearings, there's supposed to be a hearing to release that individual. Also, there could be a hearing to reduce a bond so that they could be released out of custody. Instead of courts holding hearings, judges were just signing motions to release people, which took away that victim's right to be heard on that. So we did see quite a bit, and I know it was a pandemic, but it was also very disheartening to our victims because I feel like their rights were kind of pushed to the side, and we were allowing those defendants to be released from custody because of the pandemic. So we do see a lot of increase in our complaints that took place in 2020. Our core victim rights, the very big part of it is the very first thing you're going to see in statute in our VRA is that victims shall be treated with fairness, respect, and dignity. That is very broad, but what we are looking at in something like that is the tone that somebody is using when they're speaking with the victim, how they're responding to them. Are they being professional? We have a complaint where a DA was supposed to meet with the victim and they showed up 45 minutes late. I mean, that's not respecting that victim. That's not respecting that victim's time. They had to take time off of work to meet with the DA, and the DA came in and did not apologize, did not acknowledge that they were late, just kind of sat down and said, all right, let's get this going, and made that victim feel that they were not a part of that process and their time was not valued. Okay. So taking that time to speak with the victim, returning their phone calls. If victims have a lot of questions, I mean, they have one case that they're typically working on and it's consuming their entire lives. In criminal justice system, we have a lot of cases. So being able to give that victim that time that they deserve and that respect that they need with it. So those are a few things that we kind of look at when we talk about fairness, respect, and dignity. The other part of our core rights, again, is that informed, present, and heard. The criminal justice agencies that have responsibilities underneath the VRA is law enforcement, district attorneys, courts, Division of Youth Services, the local jails, probation, community corrections, Department of Corrections, and state mental health hospitals. We do not see that nonprofits are not included in here. However, we do provide this training to our nonprofits because I believe you guys are the ones that are working a lot and very closely with victims. And we want you to be able to have this knowledge kind of in your toolbox. So if you have a victim that you're working with and they're telling you that, nobody's returning my phone call, or I haven't been updated on this, or I was not informed of this court hearing and I would have liked to have been a part of that process. You can know that, I went through this training and you have that right to be a part of that process. And there's a complaint that you could file for that. So we do provide it to you because we do consider you guys our watchdogs and you're working with those victims a lot of times just as much as our criminal justice agencies are. We have had some changes to our VRA that took place regarding how the victims were being notified. In 2019, that took place. So prior to 2019, our law enforcement, district attorneys, our courts, and judges were notifying victims of critical stage notifications automatically. So a victim just received that information. They didn't have to opt in to receive it. In 2019, we did have some change where now post-sentencing agencies, the victims no longer have to opt in for that, okay, with the exception of probation. So probation victim services, still the victim have to opt in to receive notification when it's a probation case. The reason why probation is still considered opt-in is because it was too much of a fiscal note for them to be able to manage that number of victims and notifications that they would have to provide to victims. It was like 63 positions across the state of Colorado. So they are still considered to be an opt-in agency. However, all the other agencies are not. The other part of the bill is that the Colorado District Attorney's Council determined that the bill should be retroactive, meaning that it goes into effect when the VRA went into effect, and that was in 1993. So that has kind of been a big shift, I think, for a lot of agencies, especially the Department of Corrections, because Department of Corrections now, if we had somebody who was in custody maybe 10, 15 years ago, and that victim did not opt in to receive notification, DOC now has to go back and try to locate that victim and try to find their information for them as best they can. So it's been a big undertaking for DOC to be able to enroll those victims. And I'm going to be honest with you, I just heard from the director of victim services at DOC this week, and she said they finally got everybody enrolled. It was over 30,000 victims that they enrolled. So that was since 2019, and that was in May of 2019. So it's taken them over 2 years or so to get all of those victims enrolled. It was huge for them, but it was a big undertaking, and I'm sure they're glad to have that finished now. In our VRA, we've got our definition of victim. Our definition states that it is a natural person, so it's not a corporation. They're considered a victim unless the person is accountable for the crime or the crime arising from the same conduct. The easiest way to explain that, and I'm sure you guys have already heard this, but it's just so easy, and it's a good example, I think, to help with it. But understanding of, kind of my example of that typical bar fight where you have two people who are both in a bar, they both assault each other, and they're both arrested and charged with assault. Neither of them are considered victims underneath the VRA because they were both engaging in a criminal act at the same time. Okay. And I'll talk about domestic violence and dual arrests here in just a second and kind of what that might look like. The other piece to it too is they would be a victim if there was a situation where you have that bar fight and you have person A who assaults person B. Person A is your defendant, person B is your victim. Let's say the next week they're back in the same bar, and now person B, who was our victim, now wants to retaliate and beat up person A. Okay, so person B, that is going to be your defendant, and person A is going to be your victim. They both in that time frame would be considered victims underneath the VRA because they were two separate incidents that took place. Okay, so it's two separate times. They weren't engaging in a criminal act at the exact same time. Okay. If a person is deceased or incapacitated, it could be another representative for that victim who would be considered the party to receive that notification. So that could be a plethora of individuals. It could be more than one. Let's think about a child sexual assault. You may have two different parents, they're divorced, they're no longer together, and you're going to need to provide notification to both parties. Okay. You also may have to consider on a homicide case. I know you guys probably don't deal a whole lot with homicide, but if you did, that is something that an agency would have to notify multiple people. You can have a sibling who was the murder victim, and they've got 5 or 6 siblings. Each one of those 5 or 6 victims would have that right to be heard in court hearings. They would have the right to be notified. It's not just one victim from that family. So if every single one of them wanted to speak at a court hearing, they should be allowed to do so. If there's a child victim and they turn 18 during the course of the case, they can request that they're the primary person to receive that information after they turn 18. We just had a case recently that was with the inmate who was in custody in the Department of Corrections. He was in there for sexual assault on a child. He's getting ready to go up for a parole hearing, and the child victim is now 19. She wanted to give a statement to the parole board, but she did not want her mother to be present while she gave that statement to the parole board. So she had requested that her mom not be allowed to be present. That is something that the parole, they reached out to me and said, is that something we have to allow? Can we tell mom that she can't be a party to that case because she has been the primary point of contact up until this point? Now that she has turned 18, the victim can make that choice that it is directly her. Okay. So when we were talking about the definition of victim and what it looks like for dual arrests, we often have times where law enforcement is on scene with a domestic violence case, and they're not sure who the primary aggressor is. So they're going to arrest both parties. At that time, neither party would be considered a victim underneath our VRA. So they would not be receiving services through law enforcement. They may not receive services through the DA's office. Okay. Until at some point, maybe law enforcement or the district attorney's office decides and makes that determination that we have a true victim and we have a primary aggressor. So at that point, when they make that determination, then the victim would start receiving services. So they would receive notifications from law enforcement. They would start receiving court information from the DA's office and allowed to be a part of that process. I always encourage those agencies to document that as to why they did not provide that notification to them initially. Because I think if a victim came back and said, look, I'm at the DA's office and they're providing me all kinds of resources and services, and law enforcement didn't provide me anything, I'm going to go back to law enforcement and ask them, why did you not provide anything to the victim? Clearly it's a victim of domestic violence. So they need to have some form of documentation to prove, to say that we arrested both parties and we felt that they were a party to the case, that they were engaging in a criminal act at the same time. So we did not consider them a victim underneath the VRA. Okay, so they just need to make that determination. They need to document that. The courts can also make that determination that we have a primary victim and we have a perpetrator. However, they need to make sure that they do it in writing or they do it on the record during the court hearing. We'll kind of go through our crimes really quick for you guys. I know that a lot of you have already received this information. So not all crimes are covered underneath the VRA. You'll see as we go through here that harassment is not a VRA, but anything that is domestic violence is a VRA. So if it's harassment with domestic violence, it becomes a VRA case. The same thing goes for theft. You'll see that theft is not on here, but if it's theft of an at-risk adult or at-risk juvenile, then it elevates it to a VRA crime and those victims would receive notification. So anything that has that underlying factual basis of domestic violence will elevate it to a VRA. We have careless driving causing death. It is not careless driving causing serious bodily injury, so it is only death for that one. Child abuse, bias motivated crimes. I need to update my slides. We have first degree burglary. We have added, and it came through this legislative session here in 2021, they added second degree burglary to our VRA. However, it does not go into effect until March of 2022. So just be aware that we do have first degree and second degree. If agencies don't start providing notification to victims of second degree burglary until March, that's perfectly fine. If they want to start now, they can as a courtesy just to start getting used to doing that. But they don't have to officially until March of 2022. And then just any criminal attempt, conspiracy, solicitation, and accessory to any of these crimes as well. We have failure to stop at an accident resulting in death and serious bodily injury. So we do have that SBI on the failure to stop at an accident. All of your homicide cases, vehicular homicide, vehicular assault cases are VRA. All of your assaults, kidnappings, robberies, all of your sexual assault cases, adults, children, posting a private image for harassment or pecuniary, that's a hard word, gain, those are your revenge porn type cases. So those are the ones that was kind of a newer one that was added in 2017. We haven't opened up our Victim Rights Amendment to add new changes to it since 2017. We are looking to open it up here in this next legislative session in 2022, and we are looking to add a few more crimes. We have not decided on what those ones are going to be just yet, but we are looking at a few of them. Violation of a criminal sexual assault and stalking protection order. So we've always had protection orders for domestic violence and sexual assault. We added stalking in 2017. This is not a violation of protection order against alcohol and drugs. So just so you know, you may have somebody who was charged with domestic violence, charged with sexual assault, and the courts may add something in there that says that they are not allowed to consume alcohol and drugs, maybe while they're on probation, while they're in community corrections. So they have a protection order for alcohol and drugs. If you have somebody who, that defendant who is driving down the road, they've been drinking and law enforcement pulls them over for a DUI and pulls their history and recognizes that they do have a protection order, that would not be a notification to the victim. It would be possibly a new charge for DUI, violation of protection order for the alcohol and drugs, but it would not elevate it to that VRA, even though the original offense was because it was a sexual assault or a domestic violence type case. Now, if the victim is sitting in the seat next to him, then the law enforcement agency could charge violation of protection order for that victim as well. So you may have that elevate if that victim is there. Are there any questions on the crimes from anybody?
It looks like we have a question in the chat. What is the distinction between stalking and harassment?
Oh, stalking, I believe, is more of a felony and harassment is a misdemeanor charge. It's gonna depend. I mean, harassing could just be kind of bothering them. It's all under statute, and I'd have to pull out the exact statute and read it to you, which I very well could if you'd like me to. Or I can find it and then type it up and send it to you, Becca. That might be helpful as well. Stalking is harder to prove. That's why I think it becomes a felony. You have to have that pattern that is there to show that, they've been following this person. They've been, maybe taking pictures of this person. They've been sending them repeated letters, repeated notes. Harassment could be a one-time incident that takes place, that they were just there harassing them and bothering them. It doesn't always have to have that pattern there, which I think stalking typically does have the pattern. But I could definitely research that and find you the exact statutes and read those too if you'd like.
Oh, thank you. And then we have another question. What is the difference between second degree and first degree burglary?
So first degree burglary, typically with the first degree burglary, you're going to have an assault charge with that. You're going to have, it's typically on a person themselves. Second degree burglary is of a dwelling, which I think since this was added, we didn't intentionally add this. When I say we, at the Division of Criminal Justice and our Victim Rights Amendment, we weren't the ones that initially wanted to add that second degree burglary. We didn't know about it until it was already added through a different bill that was passed. So I think with that second degree burglary of a dwelling, so it's an actual building, it's of a place that they're taking items from. We may have to change our definition of victim, because our very first thing in there says that it's a natural person. It's not a corporation. So we may have to go back and change now our definition when we open that up, because they've included second degree burglary in it. So I know that's a long answer, but typically with a first degree burglary, you're going to have, it's going to be on a person. You're taking something from them. The difference then between maybe burglary and robbery is you're going to use with force, with fear. You may have a weapon with you, and that's going to elevate it to a robbery charge. The second degree burglary is of a dwelling. It's of a place.
Thank you, Kim.
Yeah. All right. Thank you for the questions. I like getting questions. Kind of boring just to read off a PowerPoint, right? And have to listen to it. So please send more. And I was trying to change my box here. Oops. So I don't know if, just kidding. That's what I get for clicking around. So you guys can see it. I apologize. So what we're going to talk about now is law enforcement, and we're going to talk about what their responsibilities are underneath the VRA. So everything that is in these gray boxes, this is everything that a victim needs to be notified of through a brochure. Something in writing needs to be provided to that victim. Everything in this gray section is something that is available to the victim. It's not a guarantee that they're going to receive these services, but it's something that they need to know is available to them. So in those brochures that law enforcement is handing out, you're going to have my office contact information in there in case the victim feels that their rights are violated. They need to know how to file a complaint. The availability of services and resources. So what services are available? So you may have your contact information on somebody's brochure. You may have, we may have something for a domestic violence shelter, sexual assault shelters. We do ask that each agency have their own brochure, because what you're going to see up in the 17th in Adams and Broomfield County may be completely different than what you would see down in the 18th, which is Arapahoe County. So the services may be different. So making sure that each agency has their own brochure. In there, you're going to also have the district attorney's office, because you're going to need to notify victims on how they can apply for victim compensation, how they can get those protection orders if they need to, or modify the protection order, so that the district attorney's office would be in there. Again, this is what's available. We can't guarantee that a victim is going to receive victim compensation, because it does have to go before a board. They have to apply for it. But it's a great way to at least notify the victim that they have that opportunity, that they can request it. The other part of it is that the availability of the police reports. So if a victim wants to get copies of the police reports, they can request them, but it's at the discretion of law enforcement whether they release those police reports or not. The one thing that is in the bottom right-hand side is the victim's right to receive a free copy of the initial incident report. And it is free to them, okay, of all VRA crimes, and it's just the initial incident report. However, it is at the discretion of law enforcement as to when they can receive that report. They may not want to send that victim the report. They may not want them to have a copy of it if that victim has to testify in court. We just don't want to maybe changing the way they would testify after they have a copy of that. So it is at the discretion of law enforcement when they release it. It's always important to let victims know, I think, that, hey, you can have this, but you just can't have it at this time. Is there something else that we can provide them? Because maybe they'd want that initial incident report because they need to get a protection order. Maybe they need to get time off of work. They need to file something with their insurance company, something like that. So is there something else that a law enforcement agency or a district attorney's office could provide them until they could get their needs met to be able to get that incident report? Other law enforcement responsibilities, and typically this is going to be on the outside of that brochure. So the victim has a copy of the brochure. On there is going to be the case report number. You're going to have the name and contact information of the assigned officer. So if that victim has follow-up questions, who can they contact? Who can they reach at the law enforcement agency? Also, again, the district attorney's information, as well as, because that case hopefully is going to be handed over from law enforcement to the DA's office. So who can they reach out to there? They'll be informed on when the suspect is taken into custody and what that jail notification process looks like. So what's going to happen is when the suspect is taken into custody, the jail will enter the victim's contact information into their database. So it'll either go into Vine, which is their automated notification. It's called Victim Information Notification Every Day. So it's an automated system that would contact the victim and let them know when the suspect's released from custody. If a jail is not using Vine, it would be their jail staff that would notify the victim when they're released from custody. So contacting the victim, letting them know, when they're on scene, and getting that information from them to say, you will be notified when they're released from custody. Just know that it'll be through an automated system, or one of our jail staff would contact you. What information they need to know in case the suspect is harassing them. Okay, so are we going to file new charges for harassment? Are we going to help the victim get a protection order? What are the steps that can be taken to help that victim out if they're being harassed? The other part of law enforcement, and I do always say that it's kind of law enforcement and the district attorney's responsibility, is to provide evidence back to the victim when it's no longer needed for evidentiary purposes from the DA's office. So if the DA's office no longer needs that evidence and it can go back to the victim, they will reach out to law enforcement and let them know that they no longer need it and the victim can have it. Law enforcement has 5 days from that date to contact victims and let them know that it's available to them, and then the victim can get it. They don't have to pick it up within the 5 days, but they just need to be notified within those 5 days. Information on case status. So being updated on the case. We get a lot of calls from victims saying, I'm not being updated. I don't know what's going on with my case. So when we talk about what does that look like? What is an update on the case? Okay. Is the case open? Is it closed? Are there warrants that are being submitted? Is there investigation that's pending, or is it unfounded? What's the cold case status? So victims have the right to be notified on an annual basis for certain crimes. So homicide cases, sexual assault cases, vehicular homicide, kidnapping, and I believe robbery. Those victims all can be notified on an annual basis that this is still a cold case, or here's the changes that we've seen. So they will be notified of that. If for some reason the case is reopened or it's inactive for any reason, those victims would be notified of that as well. If there's going to be a no file decision, so we're not going to file charges. If it's a misdemeanor case, law enforcement will contact the victim and let them know that they're not going to file charges. If it's a felony case, the district attorney's office is the one that needs to make that decision that they're not going to file the charges. So then the DA's office will notify the victim and let them know that they're not going to file. Also for law enforcement and DAs is they need to notify victims and inform them on how to protect their address. This is not the address confidentiality program. This is something a little bit different, where a victim has to let law enforcement or the DA's office know that they want their contact information basically redacted out of reports, out of forms, anything before it gets to the defense. Anything before it becomes public record, we always encourage law enforcement in the DA's office to do it just as goodwill, and not wait for the victim to tell you to do that. However, if for some reason they missed it and the victim did not proactively ask for it to be removed, that wouldn't be a violation underneath our VRA. The one thing that they do have to redact without the victims having to ask for it is Social Security information. So just making sure that if there's a Social Security number of the victim anywhere in the report, and honestly, I don't think anybody is putting those in there anymore. I think this was from when we very first started our VRA back in 1993, we added this. But if for some reason it did get added, we need to make sure it's being taken out. Also, again, notifying victims of how to get that protection order. If a defendant wants to modify a protection order, the district attorney's office has an obligation to reach out to the victim to let them know that there will be a hearing, that the defense is requesting to modify the protection order, and the victim has that right to be heard. So notifying them of when that hearing date is and allowing them that opportunity. We don't want to modify a protection order without the victim knowing ahead of time. That could be a big safety risk to the victim. Very similar to law enforcement regarding status updates on the case. We're kind of moving into DAs. Maybe before we solely do that, do you guys have any questions about law enforcement notification process? Anything specific that you have had in your own workings with law enforcement that might come up?
I'm not seeing any questions in the chat. Oh, go ahead.
Yeah, this is Bob Hoyle. Is there a requirement that the law enforcement, when they notify someone, it's real easy just to send out an email or put something in the mail, but how do we know for sure the victim actually got that information?
Yeah, so that's a very good question. I mean, we don't know, honestly, and especially if you've got a domestic violence case and they're living together, right? Do we know that they got it, or did we know that the defendant got that paperwork? We don't know. If that's the only form of communication, we don't have a phone number for the victim. We just have a mailing address. There's the agency or law enforcement, even the DA's office, all of them are still in compliance under the VRA by sending out that letter. If for some reason the letter gets returned undeliverable, they're going to document that it was returned undeliverable and see if they can find another contact. I always say when you're mailing or not mailing, but emailing, I always ask if you can put that read receipt or put something on there to say, please let me know that you've received this information. So maybe the victims will respond to say, got it, or thank you, or something, so that those advocates are knowing that they got that information. Some advocates are texting. I am really nervous about texting. I mean, it is a form, but it's also hard to document that. You know, I mean, you could document and say, texted the victim and told them A, B, and C, but you know, you can't print out an email. You can't print out that letter to put in your documentation, those kind of things. But yeah, I mean, honestly, we don't know if, I mean, they'll mail the letter and they've gotten credit for, you know, and done due diligence to get that notification out to the victim. Unless it returned undeliverable, that's the only way we would know that they did not get it. Same thing with voicemails. I mean, we do ask that they leave the voicemail and they hope they get the voicemails. If the victims don't respond that they got it, then unfortunately we really wouldn't know.
So are they sent by regular mail or do they have to sign for it?
Nope, it's sent by regular mail. Yeah, I think if they had because it would be a financial cost to add that on there, that the victim had to sign for it, because I think those would be all certified mail. But you know, maybe a subpoena would, you know, something like that, they may have to send certified mail. Would be the only one I can think of that would be that way, but I don't think that our agencies would be able to financially afford to do that certified mail.
Okay, thank you.
Yeah, thank you.
Kim, we have another question from Chris. Is a person eligible for the victim support if they did not actually witness the crime, but it was on their property?
Not typically. They're going to have to be the primary victim of it or a witness to it. And when we're talking, and I think you're talking about like resources or services to help them, I don't know of an agency that would help, you know, if they didn't witness it, but it happened. Like, let's say, are you talking maybe like an arson, that something happened on their property, like an arson, or What do you mean that a fight took place on their property? Maybe provide me some more information. Sorry.
It was a murder that happened in front of their house,
Oh,
and they were not a witness to the murder, but they were asked to identify the murder victim. They, a lot of things have been taken as far as evidence, so I didn't know, but they did not actually witness the crime.
okay. I think that changes it a little bit, right? So if they had to identify the body, they might be considered a witness to the case. If they had to ID, that would make them a witness to the case. They may be able to receive counseling services, something like that through comp, maybe. I know that COVA, Colorado Organization for Victim Assistance, does have kind of an emergency fund that a lot of times if the DA's office and comp won't cover, that a lot of times COVA's emergency fund will help and pay for some of those things. So I think it's a possibility on something like that they absolutely would. I think it's always a case-by-case basis also. So like I said, I probably need more information before I can give you a solid answer on that. But I think in something like that, yeah, there's a chance that they may be able to get some services.
Great, thanks.
Welcome. District Attorney's Office, again, the status of the case, kind of those updates, what's happening with the court hearings, when are they being scheduled, if they're being changed, if the court dates are changed, letting the victim know ahead of time so they're not just showing up in court and we're like, oh no, we canceled that hearing or it got continued for 2 more months, come back later. And so letting them know, giving them enough time in advance. Also, the victims do have the right to be present at critical stages unless the court determines that their presence may impact the outcome of the case. So is it going to impact the defendant's right to a fair trial? That is something that the district attorney's office would work with the courts on, as well as communicating with the victim. The courts would make that final determination whether that victim could be present or not. So it's just those conversations I think that the DA's office needs to continually have with the victim and explaining to them maybe why they can't be present. The right to be informed on court-ordered HIV testing and the results of those when it is a sex assault case. And then informing victims how to opt into that notification for probation. So again, those victims are not received information automatically from probation unless they request that. Typically it's done in writing, but I know probation, if a victim called them and said, hey, I want to know what's going on with this, and gave them that verbal consent over the phone, probation can sign them up for that notification as well. Oh, what happened to my PowerPoint? Hold up. There we go. All right, so in the district attorney's office, they do have the right to consult with a prosecutor prior to the final disposition of their case. So what they need to do is the district attorney's office has to have a full frank conversation with the victim regarding what that plea looks like. Okay, so I always say that the DA's office needs to be meeting with the victim. And when I say the DA's office, I mean the prosecutor, not their victim advocate, because the victim advocates did not go to law school. They don't understand a lot of the pleas and why they're making them. They don't understand the law as much as our prosecutors do. So prosecutor needs to have a conversation with the victim, let them know what the plea is going to be, and then they go to the defense and offer up the plea. Okay, they also can have at the very beginning need to ask the victim, what would you like to see happen here? Okay, it's not just here's what we're going to do, we'll see you later. It's let's have a conversation. What would you like to see happen in this case? Then they go and talk to the defense, offer it up to the defense. The defense can say absolutely, yep, sounds good to us, and move on, and that's the plea. If they come back and say no, absolutely not, we don't like that plea agreement, we don't think that they should be getting Department of Corrections, we think they need to be in community corrections, then the DA's office prosecutor needs to go back to the victim and consult again with the victim. So anytime that plea agreement changes or there's a new, a new agreement on the table, that conversation needs to continue to take place with the victim back and forth. The victim does not have to agree with what the plea is, but they have to be fully aware of it. So the victim does have the right to be heard in court regarding that plea. So I always say if the victim is not happy with that, they will get their day in court and they get to tell the judge, look, I don't agree with this and here is why. There are certain hearings that the victim has the right to be heard at, and there's certain hearings that they do not have the right to be heard at. So everything that on this slide that is in black, the victim does not have the right to be heard, but they have the right to be informed. So they would be informed of prelim hearings, arraignments, hearing on motions, and trials. The hearings that they would be allowed to be present and heard on are bond reduction and modifications. So it's not a setting a bond, it's just the modification of that bond. Like we talked about the plea agreement already. They should be allowed to be in present and heard on sentencing hearing. And if there's a subpoena for their records, so concerning their mental health, their crime victim compensation, any of their medical history, education, the victim needs to be made aware of that ahead of time, and they have that right to be heard in court regarding that information being presented. Other stages where it's after sentencing, the DA's office has a responsibility to inform victims of appellate reviews, any DNA testing on sex assault cases, attack on judgment and conviction, petition by sex offenders to cease registration. So that's a dual role with the district attorney's office, where we have defendant who wants to stop registering as a sex offender. They're going to file a motion with the court, and the court's going to contact the DA's office and say, you need to reach out to the victim and let them know that they're petitioning this. Okay. It again is a right to be informed. The right to be heard are the modification of sentencing or the resentencing. So that is something where maybe they were in community corrections and they're like, I don't think that I deserve to be in community corrections. I want to be on probation. I'm going to ask for a modification of my sentence. The victim had the right to be heard at that sentencing hearing or resentencing. And then any hearing concerning a petition for expungement of juvenile records as well. They have the right to be heard at those. Sealing of record, we had a lot of changes on our sealing of record, and that it's been a positive change for us. We are still working on it. That is something that we would like to change still during this session that's coming up in 2022. Prior to 2017, what would happen is the defense would file a motion with the court if the defendant was acquitted or if the case was dismissed and say, hey, we would like to seal this case, and the court would sign that motion and move on, and the victim would never be made aware of it. In 2017, they've changed it up a little bit to say that if there is that motion, when the defendant's acquitted or the case was dismissed, the victim has the right to be informed that there's a chance that this case could be sealed, and a hearing will be held 42 days after the receipt of the motion. Okay, so if a victim gets that information that they're going to seal this, they can provide feedback to the DA's office. The one part that I feel like we only went 50% there in 2017, that we didn't quite go the full 100%, is that the victim doesn't have the right to be heard on it. So they can provide their information to the DA, and the DA can relay that to the courts, or the DA could just say, hey, we're just to let you know that there's a chance this case can be sealed, and that would be it. So we really want the victim to have that right to be heard, to be able to provide a statement to the courts or to the DA's office to relay that information to them. So that is something we would like to see changed. This is just to recap our rights to be heard: bond reduction and modification, plea agreements, sentencing and resentencings or modification of the sentencing, the protection order when the defense is the one that is requesting to modify that protection order, expungement of juvenile records, and then a subpoena for the victim's records as well. Just to recap. Victims have the right to be heard when they're unavailable. So a lot of times our victims want to be heard in court. They want to be present in court, but they don't necessarily want to be there in person. So maybe they can't get there financially, maybe they're out of state, but they want to be available. So the district attorney's office has that obligation to work with the victim to ensure that they are in court and that they're present. So either that be through the phone. One great thing that has come out of this pandemic is that we've got WebEx now, and our victims are able to participate over virtual to those hearings. I think some of our courts are starting to get rid of the WebEx and not using it as much just because of the technology and the difficulties that sometimes come with that. But we are trying to add, when we open up our VRA, we want to add that virtual piece into this definition to say that victims have the right to be present, they have the right to be heard, and it's at their discretion on how they have that right. So if they ask for virtual, that the courts have to make that available to that victim. We see that a lot of victims started participating a lot more in courts, and I don't know if you guys may have seen that on your side too, is that those victims were like, hey, I can be a part of this and I can keep my screen off, but I can still see everything and be a part of that process, and they don't have to see me. So I think that's been a great thing. Hopefully we will get that changed. Court's responsibilities. The court has the responsibility to ask if the victim is present on those hearings that they have the right to be heard, and ask them if they would like to address the court. So it's kind of a check and balance system, I think, for the DAs as well as the courts, to say this is a VRA crime, this is a hearing where the victim has the right to be heard. Is our victim in the courtroom? Are they present? Would they like to be here to address the court? So both of the DA or the court need to address that during the court hearing. Courts have the responsibility to determine the amount of restitution, and like we talked about, those motions to see sex offender registration, they need to reach out to the DA's office on those as well. Are there any questions from the DA's office or the court side?
I'm not seeing any pop up.
Sounds good. All right, so let's go into kind of the post-sentencing side. We won't go through all these agencies again, but you guys know who our post-sentencing agencies are. So again, we got to remember that probation is upon request, that the victim has to ask for that. The one thing that they do not have to ask for is an abscond. So an abscond would be considered somebody who is has a warrant for their arrest and it's been for over 90 days. They consider it an abscond. So at that point, those victims, any victim in probation, would not have to opt in to receive that notice. If it's a 90-day warrant or abscond notification, they won't have to opt into that. Everything else they do have to opt in for. So let's see if I can minimize that there. Maybe that's better. So upon request of probation, the victim would need to know the institution where the offender is being supervised, incarcerated, or being held. So that is kind of those. If it's probation, it depends on which probation department they're at. They would be notified of that. If it is community corrections, which community corrections facility they're at, or which jail they're being held at, which prison they're being held at. Okay, the victim has the right to be notified of that. If there's a revocation of probation or a parole revocation, the victim would be notified of that parole revocation, the revocation from probation. They'd be notified of the date they can participate in that process and be a part of it. Any scheduled parole hearing and any changes to the scheduling of the hearing. So they can be a part of that process again, whether it's a parole hearing or they're going to release them on from DOC onto parole, they can be heard during that. If it's a revocation process, they would be notified of the revocation itself. Warrants for everybody across the board for all post-sentencing agencies. Any release on a furlough, work release, or to a community corrections facility, the victim would be notified of that. I don't think right now we're doing a whole lot of work release. We just don't want inmates coming in and out of custody with the pandemic going on. But if we ever get back to doing that, that would be a notification to a victim to let them know that for the next 90 days, they will be on work release and they will be leaving, Monday through Friday out of the jail at 8, and they will have to be checking back into the jail at 5 p.m. One notification to the victim regarding that time frame is sufficient. They don't have to notify them every single day that they're going to be checking in and out. Obviously, if they didn't return and they didn't come back, they would notify the victim of an escape. So that is one of them, escape for all of the agencies, a release, transfer. So if they're doing a permanent transfer from one Department of Corrections facility to a different Department of Corrections facility, they would be notified of that. The death of the offender, projected termination date or the release date. So we always say projected because we can't guarantee the exact date of when they're going to be released from custody, off of probation, whatever it may be. As you guys know, with Department of Corrections, they spend maybe a third of their time in the Department of Corrections before they're released. So letting that victim know ahead of time so they can plan for that and expect that even though they got a 10-year sentence, they may only serve 3 years in the Department of Corrections. Court order changes in the terms and conditions of probation. So I think typically what this would look like is if we were going to extend their probation for any reason, maybe they weren't done with their sex offender treatment or their domestic violence treatment and they needed to extend them for a longer period of time on probation, the victim would be notified if there's any extension for that. So kind of just to recap, some of our post-sentencing rights to be heard is a modification of sentencing. Includes early termination too from probation. So if somebody, let's say, got 2 years on probation, they're at the 1 year mark and they've completed all their treatment, they've been a model client and they're fantastic, and probation's like, hey, we can cut this person loose, they're doing great. The victim would have the right to be heard on that. And I think that's important for them to be fully aware of, that this person is no longer going to serve their full sentence. The victim can go before the court, they can provide notification. I think most of our probation departments, and especially in the 17th, I know for sure that they are really good about, if a victim says, no, I don't want them to terminate, probation doesn't even take it to the court and have a hearing over it. They just say, okay, we'll just keep them on for the next year. They'll put them at a minimum status and see them, not maybe as frequently as they typically would, but they would still be on supervision from probation as well. The right to be heard also is a petition for expungement of juvenile records again, and then as we talked about, those parole hearings. Any questions from you guys regarding the post-sentencing responsibilities?
I'm not seeing anything pop up.
Thank you. So we do ask that our victims have responsibilities as well. They're not very much, but they still have to opt in for that probation notification. So that is one thing that they do have to do. And they have to update their contact information. So it kind of goes back to our earlier question about how do we know the victims are getting their information? If that letter is being returned undeliverable, the agency that it came back to, they can do what they can to try and find a phone number. They can try and find an email address. But they don't have to spin their wheels constantly and their time constantly trying to locate a victim, because the victims do have that obligation to update the agency as best they can with their contact information. We are seeing that a lot of victims are being notified through email a lot more frequently, which I think is good. I think a lot of victims hold on to those email addresses a lot more than they're hanging on to phone numbers as well as their physical address. So email seems to be a really good way to communicate. We can move kind of into the complaint process here. We'll talk about what it looks like. So we have informal complaints and we have formal complaints that we review in our office. We always try to resolve everything locally before it gets to the formal complaint. Our complaint process is a lengthy process. It's a good 6+ months to go through. So if it's something that we can work with the victim to maybe try and resolve with them locally, I think that's the best way to do it. So we don't have to take that long time. So the informal complaints is maybe if we have a victim that's reached out and says, I'm not getting an update on my case. I don't know what's happening. Can you please help me find out what is going on with my case? That's something that I would do. Try to find those answers for them, connect them with the right people in the right agency to help get their needs met and go that route. Did I see a chat pop up? Sorry. Yes, I absolutely agree that email is better for transient population who might need to receive these emails as well. Yeah, I get a lot of calls from and emails just saying, I don't have a phone number right now, but here's the best way to get a hold of me. So I absolutely agree that email is a great way to go for sure. Thank you for that comment. So that's the informal complaints. If a victim wants to file a formal complaint, they definitely can do that. They have to get the complaint form through my office. It's not something that we have on our website that is available because I want to screen. I want to make sure that what they're filing a complaint even falls underneath the VRA, or that their lines and their reasoning for filing a formal complaint is in line of what our goals are. So those are some things that we would want to do just to make sure. We're based on system change. So I want to make sure that, if their goal is that they want to get a prosecutor fired or lose their law license, that's not anything that we have the ability to do. Okay. So if that's their goal for filing it, then maybe this isn't quite the right process for them. So we're going to work on doing system improvement. We want to make sure that this doesn't happen again in the future to other victims. And that is something that I tell them up front. So that's part of our kind of screening process as well. If it goes before the VRA subcommittee, it goes, we meet once a month. These are the individuals who sit on our subcommittee. We have 7 individuals. And as you can see, there's quite a bit of range for our victims here to, kind of go before to review their stuff. So we've got everybody from almost every criminal justice agency here. We're also spread out across the state of Colorado. So it's not just the Denver Metros who are meeting. We've got people in the rurals that are also on our subcommittee to help us kind of keep that rural perspective when we are looking at those complaints. If an agency is found in violation of the VRA, these are some things we're going to look on. And again, we're based on that system change. So we're going to look at doing a VRA training. This is kind of a basic VRA 101, just covers all of them. But what we would do is provide a more in-depth one. So if it was against a law enforcement agency, we would have a specific only to law enforcement. And I would typically have my sheriff come out with me and provide the training to them as well. Sometimes I think having that sheriff or that DA with me always kind of helps enforce it a little bit more. Maybe the impact is a little stronger as well. Our subcommittee is really strong on policy. So show us your policy on how you provide a notification to the victim. How do you update them on this? Whatever it is, whatever the violation is, we're going to kind of tailor that policy to that, show us your policies on this. And we may require that they do a victim empathy training. That is typically going to be if there is a fairness, respect, and dignity type complaint, we would ask them to do that. We may also do a meeting with the victim if that is something that the victim has requested. We would never make a victim meet with the chief of the probation department or the chief of the police department if it's not something that the victim themselves has requested. I don't think that could be very helpful. We're not a do-over process, so we cannot make courts hold hearings again. We can't make the DA's office file cases or law enforcement arrest anybody. We don't have the ability to make probation revoke somebody or to change the outcome of the case. So again, when we're talking about that screening process, if this is something that the victim's goal is, again, this may not be the process for them. And we just want to make sure that they understand that moving forward. There's certain things that the VRA doesn't cover. We don't cover cases that are filed in municipal court. We don't handle anything that is police misconduct unless it's like a fairness, respect, and dignity type thing. But if it's police brutality, we're going to refer that victim to internal affairs to file an investigation to them. We don't have any purview over the manner in which a case is investigated. So if the victim is upset because they provided 10 witnesses and our law enforcement agency only investigated and contacted 5 of them, that's not under our purview. We feel that the DAs and our law enforcement are experts, and there's a reason maybe they only contacted 5. The decision as to file charges or not file charges is not under ours. And then again, we have no discretion over what the plea agreement is, as long as that victim has been notified of what the plea is, they've been consulted with, we have no discretion on what that final plea becomes. And then just this quick little graph for you guys here. I kind of flew through that last part because I was looking at my watch, realizing where I was at in my time. But this is a quick graph that just shows the last 10 years and the complaints that we receive. Typically, we have received about 35 complaints, and this is across the entire state for all agencies. And these are just the formal ones. So the informal complaints, we get about 175 that we manage, and then 35 or so. In 2020, we had 42 complaints, and I think 2021, we're right on target for about that as well. We're pretty busy this past couple years. It's been a little crazy. So that is kind of where we're at. I will put this up here, and then I will just open it up to you guys if you have questions. My contact information, you are all very welcome to reach out to me. You can email me, you can call me. One thing to note, we found out just last week that our 888 number here apparently got hacked. So not that you guys would use the long distance call when you are local, but just so you know, don't use the 88 number. Apparently it got hacked and it doesn't work. So the 303 number is good for me, as well as my email. If you guys ever have any questions that come up regarding the VRA or a victim that you're working and you want to help get resources, anything like that, I'm happy to help with you guys as well.
Kim, thank you so much.
Yeah, absolutely. Maybe I'll stop sharing and open it up. That way, if there are questions you guys can ask, or if we're on a time crunch, we can move on to, and you guys can email me your questions and I'm happy to email you back.
I think what I will do is stop the recording at this point.